I call on Government Order of the Day number 7.
Trans-Pacific Partnership Agreement Amendment Bill, Committee stage.
I declare the House in committee for consideration of the Trans-Pacific Partnership Agreement Amendment Bill. Mr Chair.
Mr. Speaker.
Mr Chairman.
It's only taken us one question. Okay. You got that right?
Yeah. Yes. Be the very last page, Mr Chairman. That's your question.
Members, the Housing Committee for consideration of the Trans-Pacific Partnership Agreement Amendment Bill. Pini Hanare, Tanakwe.
Sir, I seek leave for all provisions of the bill to be taken as one debate, with separate votes on each question at the end of the debate.
Leave is sought for that provision. Is there any objection? There is no objection. So the question is that parts 1 to 12, schedules 1 to 4 and clauses 1 and 2 stand apart. Point of order, Grant Robertson.
Mr Chair, I raise this point of order now so that there is perhaps some time while the debate goes on and over the dinner break for a considered ruling from you. I'm raising this point of order under Speaker's Rulings 130(2) around the issue of commencement dates. Speaker's Ruling 130(2) says an amendment to a commencement date must provide certainty about when the Act is to come into force. An amendment that relies on an indeterminate event is not in order. The amendment that has been made in Clause 2.2 of the bill, commencement date, says that date must be the date on which the Trans-Pacific Partnership Agreement done at Auckland on 4 February 2016 enters into force. Mr Chair, as is well known and perhaps dependent on events that might take place tomorrow in the United States, that is not a date on which there is any certainty at this time. And I am concerned that the amendment that is proposed in the legislation under Clause 2.2 in fact breaches Speaker's rulings and would be out of order. And so I would seek your guidance on that and perhaps a considered ruling.
Well, thank you for that. I will seek some guidance on this matter. This was a provision that was put in place by the Select Committee and agreed to at the second reading. So it's actually there. That's happens to be here, but I do take on board what you're saying, and I'm happy to seek advice on that matter. So I'm looking for a caller. I'm calling Grant Robertson.
Thank you very much, Mr Chair, and it's a pleasure to take a call in the first of a number of calls I hope to take in the committee stages of the Trans-Pacific Partnership Agreement Amendment Bill. And I want to start my contribution, Mr Speaker, as I would have done had we been doing a clause-by-clause debate, which is to start with Clause 1, which is the title of this bill, which actually emphasises part of the problem that we have here today. So this Act is called the Trans-Pacific Partnership Agreement Amendment Act. As is the nature with legislation like this, there isn't actually any one piece of legislation to amend. There's a series of very small and in many ways inconsequential amendments to a number of different acts. The Agricultural Compounds Act, the Copyright, actually, they're not inconsequential, the Copyright Act amendment ones, and I'll come back to them in the fullness of time, but also around the various trade provisions and acts that we have. That is part of the issue here, is because for many New Zealanders, they have been concerned about something called the Trans-Pacific Partnership Agreement, the TPPA, as named in Clause 1 of this bill. But as such, it doesn't exist in New Zealand law. And that highlights the problem of the fact that this Parliament has not had an adequate opportunity to debate the overall nature of the TPPA and the ability for New Zealanders to reflect their concern about that. And I think over the years, Mr Chair, it'd be fair to say I've changed my view somewhat around Parliament's role in looking at agreements like the TPPA. Because as trade agreements themselves have changed and developed from being fairly basic agreements about market access and services and access of goods and services to markets to the more complex agreements like the TPPA, the 6,000 odd pages of it, I think there is a greater case for more public scrutiny and more public debate on whether New Zealand should be part of these agreements. And the issue we have today, Mr. Chair, as we come to debate this is New Zealand's already signed up. New Zealand's already signed up. This is the ultimate box-ticking exercise. This is the ultimate arrival in Parliament where... Todd Barclay's just told me to sit down. That's not going to happen, Mr. Barclay. In fact, Mr. Barclay, if you keep that up, you're going to be here for a very, very long time, because this piece of legislation isn't supported by a lot of New Zealanders, not because of the detail of the acts that are contained, the amendments to the acts that are contained within here, but in part because Mr. Barclay and his government have decided not to take New Zealanders with them, have decided not to have a proper discussion with New Zealanders about the benefits and the costs, but rather to sign up and then come looking for a rubber stamp from this House. Well, that's not what we're elected for, Mr. Chair. We're elected as members of Parliament to actually represent our constituents, to debate and decide upon what is best for New Zealand. This is the sovereign Parliament of New Zealand, and I'm sorry to say that the way that the National Party have approached this agreement means that the sovereignty of this Parliament has been undermined. So, Mr. Chair, I would say when I look at the title clause and I say the Trans-Pacific Partnership Agreement, I wish we were really debating that agreement. We were really debating with the pros and cons of that, the costs and the benefits. But instead, the legislation is actually a series of technical amendments to various pieces of legislation that are affected. There should actually be, I would say, Mr. Chair, considerably more bits of legislation being amended here, were it not for the fact that New Zealand has actually largely removed most of the tariffs that would have been, potentially in another country's piece of legislation ratifying the Trans-Pacific Partnership Agreement. Because over the years, our lay-down misere approach, as I discussed it in the second reading, to trade negotiations means New Zealand ain't got much left when it comes to time to negotiate in trade agreements. And that is the case for New Zealand when it comes to the TPPA. The second point I want to make about the name of this piece of legislation is actually in some ways it's a bit more honest than some of the commentary from the government has been about what's actually happening here. Because we keep getting comments from National Party members about anyone who's opposed to this is opposed to trade. Well, what utter and complete nonsense. I've stood in this House before and debated free trade agreements, and they've been called free trade agreements or free trade ratification agreements, Mr. Chair.
Grant Robertson.
And they've been called free trade ratification agreements. This one doesn't say that. This one calls it the Trans-Pacific Partnership Agreement. And that's actually a reasonably fair reflection of an agreement that goes well beyond actual market access, the actual tariff debates. In fact, we don't have a lot of that in here. What we have are things like amendments to the Overseas Investment Act. Because actually, the Trans-Pacific Partnership is an agreement, yes, about some market access provisions, but also about the way governments regulate, the way governments make their decisions, the kinds of decisions that this Parliament should be making. And the frustration for members on this side of the House, Mr. Chair, is that we're not actually in here today debating, for instance, the decision of the National Party to deny a future government the right to say who it is who should be able to buy residential property in New Zealand. In other parliaments around the world, when they're debating the ratification, when they're in Australia or when they're in Vietnam, they will be debating that. Singapore, they will be debating that because those countries decided, yes, we will actually reserve the right of our sovereign parliament to make a law in that way. But that's not here. That's actually not one of the clauses that we get to debate today because the government didn't come to this parliament before it signed up to that, or in fact signed away the right for New Zealanders to do that. So this agreement, the Trans-Pacific Partnership Agreement, is fundamentally different from the China Free Trade Agreement or the South Korea Free Trade Agreement that we've debated before in this House, and that the Labor Party has not only initiated, but in the last 8 years been prepared to support the ratification of those agreements. This one goes further. This one goes further, and at the same time, the government has done as little as possible to take New Zealanders with them in going further and explaining what some of those benefits might have been and being honest about what the costs might have been. And I do want to say this now, the Minister and the Chair is here, because he wasn't here when I said this in the second reading. And that is that actually I think he's started to do that now that he's got into the job. He's actually started to get out and get around New Zealand and say, this is what's happening. Well, sorry, too little, too late. Because the previous minister, Minister Grosser, knew so much more than the rest of us did. About everything, actually, but about this in particular. And he was, and he didn't need to do it. He knew everything. Free trade was in his blood. This is the man who once described, he once said that CER should be called GER, Grosser Economic Relations. Because he was the third secretary in the embassy in Canberra when it was passed. It's that attitude from Mr. Grosser that typifies what's wrong with this agreement. Negotiated without being transparent for New Zealanders about what was involved. Relying on constructive ambiguity, as he told Mrs. King and myself in a meeting where he said we could talk about everything he said. And when we questioned around whether or not New Zealanders would pay more for medicines because of the changes that were being made here around patent law, he said there was constructive ambiguity. Constructive ambiguity. That's as good as it gets from this government when it comes to the TPPA. So, Mr. Chair, it's difficult for members on this side of the House to be able to stand up and make the contributions that we need to make on this, because actually the legislation in front of us does not give the full picture of what the TPPA is, and we have not been included in the debate at the appropriate time. And I know from when we did less complicated trade agreements like the China FTA, we worked hard in government to make sure that stakeholders knew. We met with unions, we met with environmental groups, we met with businesses, and we talked through what we were doing. We trusted those people to have New Zealand's best interests at heart and be part of the discussion. Not this government. Total veil of secrecy, and then Mr. Grosser telling us at the end to trust him that he knew everything. Well, the sad reality is he told us this would be a gold standard agreement. It is not a gold standard agreement. It falls miles short of that in every respect. And at this stage, it doesn't even look like it's going to enter into force anytime soon. So here we are, debating to ratify something that probably won't ever exist, that will be renegotiated and was put forward by a government that did not do for New Zealand what it should have, Mr. Chair. This could have been done so much better than it has.
I call you on.